Yes, I salute you all. Thanks for listening and thanks for watching. So basically, subscribe to the channel, like the videos. Your subscription motivates me and also motivates my team similarly. But what you have to know, today we are under the introduction to law, or the fundamentals or the foundations of law. And basically the topic that we are going to emphasize on, it is the topic of ADR, alternative dispute resolution, basically. And what you have to bear in mind, or what you have to place in mind, is that ADR is, and as you hear the word alternative dispute resolution, we all know that all disputes are settled in courts of law. But here ADR comes and says that we can settle the disputes other than going to the courts of what? Law. This is a form of resolving or settling disputes other than litigation. Litigation, that's courts of law. Other than litigations, or controversial to what? Litigation, basically. Or what you have to put in what? In mind. So here realize that ADR has various forms, and what you have to know, it is governed like with 3 statutes. We have the Arbitration and Conciliation Act. We have the Arbitration and Conciliation Act as amended. Realize that these acts act as an authority to act as an authority to the what? To ADR, basically. It is recognized by the courts of law. It is recognized by the laws that we have in the country. That is ADR, alternative dispute resolution. So as we move forward, we are going to realize the forms, the various forms of ADR. And one of the forms that we are going to look at is arbitration. These are some of the forms how ADR can be what? Can be conducted. And one of it is what? Is arbitration. When you read arbitration, basically what I can tell you, this is where a third party comes in and his decision is binding, or the decision that he or she dictates must be followed by both of the parties, or the parties to the what? To the dispute, basically. An arbitrator is like an adjudicator, or someone that a judge. His decision, or the decision that he makes, is binding on both the two what? The two parties. That is to deal with arbitration. And when you read section 2, subsection 1 of the Arbitration and Conciliation Act, realize that it emphasizes, or it portrays that here an arbitrator it talks about the arbitration agreement. Basically, this agreement, once two parties make an arbitration agreement, in case of any dispute, the arbitrator must get what? Must be involved. This deals basically, what I can say, that this deals whereby realize that most of the parties have failed to come to a consensus. That's when an arbitrator comes in, or that's when an arbitrator comes in and intervenes and makes a final decision. And basically, when you refer also to section 28 to 32 of the Judicature Act, also provides for that provision of arbitration, basically. It says that the High Court can refer matters to an arbitrator. You get, we have seen many scenarios, even up to date. Nowadays, courts are advising clients to use ADR, to use alternative dispute resolution, other than coming to what? To court. You get, realize that sometimes it is something that is of what? Great advantage, or something that is advantageous in that sense. Realize now, when you move forward, that is to deal with arbitration. So when you go to, there's another mode of, another mode of what? Of ADR, which is conciliation. When you move to conciliation, basically here, the party is what? The party that gets involved is the party that it comes, actually, conciliation, the essence of the party is coming in so that the parties can come to an agreement. You understand? That is a conciliator. A conciliator, unlike an arbitrator, a conciliator, his decision is not binding. You understand? But however, his involvement is just to make the parties to come to what? An agreement. You get, when you relate to section 51, talks about the appointment of a conciliator. Section 51 of the Arbitration and Conciliation Act. When you also refer to section 53 of the Arbitration and Conciliation Act, also provides for the same. You get, provides for the same of the conciliator being between the disputes so that they can come to what? To a consensus. You get? His decision is not binding. You get? That is to deal with conciliation as a mode of alternative dispute resolution. Then we also have another mode, which is mediation. Mediation, just like it is similar to conciliation, but for it, it's mediation basically. Here, the third party brings the dispute, the grievant parties or the parties in the grievances, brings them in an interaction. You understand? For actually, the reason that's why they say that it is similar to conciliation is that both their decisions are not binding, unlike arbitration. But here realize that a mediator comes in and brings that interaction between the two parties so that they can come into what? A consensus, into an agreement. You get? That's why they say that mediation, it is similar to what? It is similar to negotiation. You understand? It is similar to negotiation. The parties are brought on table to negotiate so that they can come to what? Into an agreement or into a consensus. You get? So basically note that in mind. And also when you read mediation, when you read section 66 of the Arbitration and Conciliation Act, you get? Realize that it provides for that mode of what? Mode of ADR, which is mediation. You understand? And remember, the only thing when I relate to the Arbitration and Conciliation Act as amended, it recognizes only two modes, that is arbitration and conciliation. But it leaves out mediation as another what? Mode. But however, the Arbitration and Conciliation Act, for it recognizes what? It recognizes ADR, mediation basically. And also I can refer to also a further example where I can say is that when you read section 80 and section 82 of the Land Act, provides for that presumption of mediation under the customary what? Customary dispute. You understand? It provides for that gap of mediation or negotiation under the customary dispute committee or dispute resolution, basically. So note that in mind. Mediation is also a form of what? ADR. You get? And so we have seen three forms. You have arbitration, conciliation, and mediation. Mediation is similar to conciliation, but they differ. And negotiation is also the same as what? Mediation. The owners of these parties, they are bringing the parties into negotiation. They are bringing the parties into an agreement or into an interaction so that they can come into what? A consensus. That is what they call mediation. You understand? So when you realize these forms, or when you analyze all these forms, realize that even there is also a good case or a leading case under ADR. It is on arbitration. The case of the East African Development Bank versus Ziwa Horticulture Exporters Limited. Realize that these parties or the aggrieved parties had made what? An arbitration deed. But however, the other party wanted to shy away from the deed. But the courts ordered for an arbitrator to intervene so that they can come into what? Into a conclusion. So basically note that in mind. That is a good case on what? On arbitration. It is very, very good case and a good case for us to read. So basically note that in mind. So when you realize that these modes, or when you read through these modes, realize that these modes, for you to understand them, first know each mode, what it's all about. Then relate them to the advantages and disadvantages. What do I mean advantages and disadvantages? Those are the key questions that examiners ask. You get? Examiners ask. Basically, sometimes if you're a good student, you can state each mode and give advantages and disadvantages on each mode. But if you're not well sure, you can generalize. You understand? Advantages of ADR, disadvantages of ADR. But if you're sure, you can say that you can start with mediation, you talk what is it all about, give its advantages and disadvantages. You go to mediation, you give its advantages and disadvantages, like that. But if you're not sure, just generalize. But however, me, I'll generalize, since this is just a wrap-up discussion. So the advantages and the disadvantages of ADR. First of all, basically what you have to bear in mind, or what you have to put in mind, is that first of all, it saves time, it is cheap. Since the fact that it doesn't have fees, lawyer, what and what, and it also saves time. Since when you realize court, compared to court proceedings, court has many cases, but here realize that it is a one-on-one, and also it brings a fair, or just what? Interaction. It brings reconciliation between the two parties. Realize that there is room for interaction, most on mediation and reconciliation. It gives that room of interaction whereby parties can what? Reconcile. And also there is enforceability of the decision making that is made on the aggrieved party, most on arbitration. You get? But for you to analyze this advantage, you must understand the modes of ADR. Then when you go to the disadvantages, the disadvantage, one of it, realize that the disadvantages, there is bias, most on the arbitrators and mediators and reconciliators. They are biased sometimes. There is corruption and bribery. That is obvious. Anything that's done behind the camera, since they are normally, there is a lot of privacy in them. You understand? Realize that there is a lot of what? Corruption. There is a lot of corruption to that extent. And also when you realize that another disadvantage, you realize sometimes it wastes what? It wastes a lot of what? A lot of time. You understand? Since actually, and when you look at arbitration, it doesn't give room of what? Room of interaction. You get? However, there are more advantages and disadvantages to these modes. But that's the preamble that I've given you. But other than that, you can read as many advantages and disadvantages as you can. You get? But other than that, thank you for watching and stay blessed.